Hello, hello, it's Pattyjo, and it's been so many days. So, friends, I think we are picking up still with poor Detective Carpenter and Daryl trying to punish him for being so mean. Oh my goodness, you're so mean to me. All right, let's just get moving.
Thank you so much. Move enough water.
That's my cash thing. I should probably do that before I start.
It's time. I might have to get me more water too. Thank you so much.
Sorry,
Move enough water.
feeling ick today.
You have water?
Yeah,
You have enough?
run through this one.
Alright, we'll make sure there's another one. Alright, I can't see behind the monitor. What you got or don't have.
Thank you.
There's a water, thank you for the water. I'm so important. Have your servants give it to you. Like the way you set it down on the table.
Alright, thank you. Everyone, please be seated, and Mr. Brooks, you may continue with your questioning of this witness.
Alright, so I've got some pauses coming up because there's a hole in my roof. So I apologize. Let's moving along.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah, so in regards to the first interview at that point, as I kind of stated in my earlier testimony, we didn't know exactly where you'd end up. Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was attempted and was over with.
And do you recall if you made that determination yourself, or was it your supervisor or something of that nature?
Objection relevance.
Ground.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective Casey.
And at that time, that's when you learned that Muskego Police Station was a viable location.
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any?
This is the third recording, and I usually do like an hour or better. And we are still beating this stupid horse. What a narcissist. Okay, so from what I can understand from his tiny little smooth brain with no ripples in it whatsoever, he is like a functional jack-o'-lantern, as far as I'm concerned. He is questioning and debating really the valid processes that were used to question him. So we all know we have rights if we're being questioned. We all know that we have the right to remain silent, which he has no capability of. We all know that we have the right to an attorney, which he did not avail himself of because he thought he was smarter than everybody in the room, which we saw, while he was trying to sneak a phone call and all kinds of other stupid stuff. Now he's trying to say, why was it at this department? Did you make that decision? Is it policy? Can we see your MOPs, your SOPs, your standard operating procedure? You know what? None of this makes any difference, and all of it was addressed probably prior to, otherwise it wouldn't have been admissible information. So it was all laid out in prior pre-trial hearings. That's the way. Otherwise, they wouldn't have been allowed to even present it as evidence. You're not helping yourself, Daryl.
Any of your investigations before that evening?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
I had not, but when our department first closed, that was given as an option for us, being we didn't have our own municipal lockout.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
And do you recall how that interrogation started?
Yeah, you have the right to remain silent.
Yes, I explained to you I had more information about the domestic, and that's what I was looking to speak to you about.
Do you recall making a statement that we all know how women can be? They're crazy?
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
So it'd be fair to say that that comment doesn't reflect your opinion of women.
Correct.
Why did you feel that would have been necessary to be able to report that you stated?
Because you think women are garbage, Daryl. He was trying to make a connection. Oh, I like that picture. Let's see if I can figure out how to make it. Drag and click. Okay. I like this. Look at that. Yeah, Daryl. He made the comment because he thought you felt women were trash.
That you already felt that you had.
Because it was just being relaxed. I was relaxed. I didn't want to make you feel unnecessarily nervous. We had been, talking to each other in the casual conversation from the night before, very civilly, very openly about non-custodial topics. And I was just continuing to go along those lines. It wasn't anything other than to just communicate with you on a stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Objection,
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
That's the same question.
objection, same.
Grounds.
Overruled. The witness may answer.
Oh my God, she caters to it.
Perhaps, maybe.
So it'd be fair to say for the situation, you felt that the conversational tool you use would be more appropriate at that time?
So ask that one more time, please.
You felt that, would it be fair to say that you felt that at that time, the conversational tool that you use would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assume that would put the detainee more at ease by starting the conversation with along those lines?
I wanted you to be relaxed. That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda. But I always want all the people I talk to feel comfortable and be willing and know that they can talk to me if they want to.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement,
Grounds.
and mischaracterization of the evidence.
Grounds.
Well, sustained as to the form of the question.
It would be fair to say that the second interrogation was pretty long. Would that be fair to say?
Yes, sir.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question.
Grounds.
The interrogation began, the court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question. It calls for a legal conclusion. Next question.
Did you immediately start the second interrogation with the reading of Miranda rights?
No, that is not the first thing I stated to you. First, I explained to you what I was wishing to talk to you about.
And do you recall how long you were in that explanation phase of the interrogation?
Maybe around 15 minutes, 16 minutes.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
Sustained. Calls for a legal conclusion. Misstates the testimony as well.
You read
Next question.
You read the Miranda rights after 15 minutes.
Yes, thereabouts.
Do you recall why you didn't start the second interrogation with the Miranda rights?
I'm not required to read them immediately, so those first 15 minutes were verifying your personal information, explaining that I now wish to talk to you about a domestic involving your girlfriend, and then I read them before asking you any specific questions about that event.
Would it be fair to say that you had already obtained personal information the night before?
I think that a lot of people have a misconception because of TV, and probably I did for a long time too. But the Miranda rights are read before interrogation. They're not necessarily read upon arrest. And the way they've fashioned it, from what I can see here and from what I've seen before, the demographics for the person are they are done before each questioning. It's not like separated. And so basically, if they're going to, they do it together, so they know they're doing the Miranda rights for the same person, for the correct person. Makes sense.
I had, but I didn't have it in front of me, and I have to recomplete the whole Miranda sheet. So I had to refill out the top form of the sheet, which is your name, so I had to verify that.
So it'd be fair to say that you had obtained personal information that you didn't bring with you for the second interrogation?
I did not have your information written down at that point. Yes.
Do you recall why at that time you didn't have the personal information that you had already obtained?
No.
No, as in?
I don't recall why I didn't have it.
And you said you started off the second interview with information about domestic allegations. That'd be fair to say?
Yes, after reading Miranda, if that's what you're asking.
No, I didn't.
Right. I don't know what are you asking then? Just so I'm clear.
The question was, again, you started off the second interrogation with domestic allegations.
Yes, that was part of the beginning, explaining to you those allegations that had come forward. Things I didn't know about the night before.
Any reason why you wouldn't explain the real reason why the detainee was being detained?
At that point, the domestic was part of the real reason why you were being held in custody.
He is so mad. Daryl is so angry. He is so angry because they didn't march the whole parade of charges before him so that he could explain it away and narcissistically squeal away like a weasel. Here's another one. He's either a weasel or a chicken, as Sue Opera called him, or just an ogre troll garbage goblin. Ugh.
Did you have any more knowledge about the incident from the previous night at that time?
Are you referencing the parade aspect of it?
Yes.
At that point, yes, I did.
And why wasn't that information given to the detainee at that time?
As I explained in my earlier testimony,
100 times, garbage goblin. I'm mad. I'm Daryl and I'm mad. Ugh.
the idea behind the second interrogation was I began with the domestic abuse issues, questioned you about those, and then moved into the parade aspect of the investigation.
And why not start with all the information you knew?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
Can you repeat the question, sir?
Why would you not start the second interrogation with the information that you knew?
In regards to the parade?
In regards to all the information that you had at the time?
Well, as I stated again in my earlier testimony, as we began the second interrogation, I explained it was about a domestic with your girlfriend, Erica Patterson. But again, I can't give you all the details because part of gauging truthfulness and avoiding I'm not leading you is not telling you every single thing. I had told you she alleged there were physical injuries, but I can't really tell you what they were because I want to see if you're going to be honest and tell me what they were. Additionally, telling you what the injuries were as far as Mr. Patterson could cause you to create a lie to avoid those. And it's the same issue with the parade.
Did you speak to the complainant of the domestic allegations at that time?
Objection. The use of the word complainant.
Sustained as to the form of the question.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
So it would be fair to say that you, at that time, didn't know if they were true or not.
No, that wouldn't be fair to say.
And why would that not be fair to say?
Well, hold on. It's for this jury to determine the facts of this case, including the domestic allegations. So I'm not going to let a witness comment on his belief or not on any other witness's testimony or information. Fair enough?
I apologize.
All right. Next question.
Had you at any time before the second interrogation spoke with Ms. Patterson?
No.
You made reference, I believe it was in both interrogations, to reading. It was in reference to the Miranda rights, stating that if I was at home on my couch, do you recall making that statement?
Yes.
And what do you mean by that? At home on my couch. What do you mean by that?
Well, Miranda is strictly custody based, so I could interrogate you or question you about a matter in which you were a suspect at your home, and I would not be required to read those warnings. Being we were in custody, we were at the Muskego Police Department, you've been handcuffed, you've been transported, custody was obvious. I'm required by law, therefore, to read you those rights based on you being in custody.
You made a reference to that's a requirement by law. In custody, you have to read those by law.
Objection. Relevance for this hearing.
I'm going to sustain that objection. I believe it's also been answered. So, next question.
Do you recall if those Miranda readings are to be at the beginning of interrogation?
No, this has been asked and answered as well.
Sustained. It has. It also calls for a legal conclusion, which is not appropriate. Next question.
In the first interrogation, you spoke of the detainee being detained for loitering and prowling. Did you make reference to that in the second interrogation?
No, I did not.
Any reason why?
By the time of the second interrogation, the primary focus had shifted to the domestic incident between yourself and Erica Patterson, and also the parade, because by this point I had more information about the parade and that incident specifically.
So what happened to the initial loitering and prowling allegations? Why were they discarded?
At that point, they were not the primary concern. Eventually,
Because you're a humongous monster and prowling is a mere inconvenience compared to the laundry list of crimes that you committed. Ugh.
the interrogation came to a stalemate, so to speak, and we didn't discuss it. The primary concern was the domestic issue between you and Ms. Patterson, which at the time I began to start the first interrogation, I didn't know anything about. And then the fact I now had more knowledge on the parade.
So do you recall who made the decision for the loitering and prowling allegations to be discarded?
Your Honor, I think that mischaracterization of the testimony, the fact that it wasn't charged isn't on this officer.
I didn't say anything about it being
Since that's
charged.
not an evidence for the other reasons indicated by the state, I'll sustain the objection.
Just for the record, I didn't say anything about it being charged.
Understood. My ruling stands, even with that.
So would it be fair to say that in both interrogations you gave different reasons why the detainee was being detained?
The explanations that I explained to you did change. However, again, the domestic was not known at the time, so that circumstance changed a bit. That became something that was of importance to us. Domestic abuse is taken seriously. And again, there was more knowledge about the parade.
Would it be fair to say that because of the change in information between the first interrogation and the second interrogation that can be misleading?
Objection calls for speculation from whose perspective?
Wow.
Sustained as to the form of the question.
Is it fair to say that someone who is being detained would perceive that as being misleading when there's two different reasons why they're being detained that was told to them?
Objection, speculation. This witness cannot know what is in someone else's mind.
Calls for
Daryl, as fast as these people caught you, they were not able to catch you before you and your goblin narcissistic self committed a whole bunch of crimes because that's all you do is commit crimes. Ugh.
speculation.
He's got nothing to ask him of any kind of
At any point in the interrogations, did you knowingly lie about the information that you had?
Yes.
There was information I withheld from you, yes.
Yes. The police lie during interrogations. Omission and commission. You got two separate kinds of lies. Omission and commission. When you commit a blatant lie, in other words, you tell somebody, I weigh 120 pounds. That's a blatant lie. I do not weigh 120 pounds. I haven't weighed that since I got the driver's license before my kids. So I have lies of omission. I never bothered to tell the Motor Vehicle Association that my weight has changed. I've just, passively let them believe that it's the same. Where anybody with eyeballs can see that clearly that number has changed. Do I think police should lie? No, I don't think anybody should be lying. I shouldn't be lying, okay? But the bottom line is this. He's correct that if he marches all of his suspicions and things that they have backing for to the person who's a suspect, that it opens it up to muddying the waters. That person can lie. The person can do exactly what Daryl is planning on doing, which is spinning a tale of his own lies. It's so ironic that Daryl is stuck on the police lying when many, many, many times it has been validated that it's legal for them to do so in these cases like this. When Daryl is like such a huge liar. Like, it's amazing. Okay, here we go.
So it'd be fair to say that you lied.
Yes.
Objection. This characterizes this officer's answer.
It's argumentative, sustained as to the form of the question.
Just for the record, there is a point in there where you
Sustained
stated
as to
that
the
he
form of
lied.
the question.
Why did you continue to withhold information repeatedly?
Because it's his job.
I guess at which point? Through the whole, are we talking about in the middle of the second interrogation at this point? What
Do both
point are we talking about?
interrogations. Do both of them.
Well, there really wasn't a first one, because when I got interrogation doesn't truly begin until I'm asking you incriminating questions potentially after you've agreed to waive your rights and speak, something you didn't do on the first day. On the second one, quite honestly, it goes back to what I've stated in my earlier testimony. I wanted to make sure the information I was getting from you was truthful. I wanted to make sure that I didn't lead you down a path of potential lies. And third, quite frankly, Mr. Brooks, I didn't believe if I gave you the information you were going to tell me anything.
You made reference to the first interrogation saying that there was no waiver of that interrogation.
Objection.
Oh.
I'm referring to what he just said at the beginning of the answer.
I'm going to sustain the objection. Next question.
Grounds for the sustain.
Next question.
Grounds for the sustain, Your Honor.
Next question.
So I can't get no grounds. Okay.
Because you're stupid and they're trying to help you? Oh. It's just hide the grounds.
So you made reference to not being sure if you would. I'm trying to remember exactly what you said. You wasn't sure if you were going to get the information you were seeking?
Correct.
And is that what led you to lie about the information you knew?
Objection. This characterizes the testimony.
Grounds.
It's argumentative, sustained.
Did that lead you to not be forthright about the information you
Okay,
knew?
that's the same question.
Argumentative.
Sustained as to the form of the question. His words were that he withheld. You may.
That led you to withhold information that you had obtained?
I'm sorry, did what part with all that? Can you restart the question?
He doesn't remember it after.
Because you were not sure if you were going to get the information you were seeking, that led you to withhold information that you had obtained.
Well, again, as I've stated in prior testimony, strong part of the reason I withheld information is I wanted to gauge how honest and truthful you would be. I think it's
Plus, the police are allowed to lie. They're allowed to just blatantly lie.
important to know you lied to me, and this was proven by evidence about your mother owning a vehicle. You know, You lied about
Oh my God,
coming
here he
out
goes.
here in a tan, possible Kia. So there were lies that were
Strike
told at this
that.
point. You lied about being body slammed by officers. That was later
Hold on.
proven to
I
be
wanna
not true.
Advise the jury of a couple different things at this point. Obviously, ultimately, the juror will determine the credibility of all witnesses and the weight of the testimony to give for any witness. So whatever any person's opinion about the testimony or previous statements or information from another individual, I'm telling you, is not evidence. You need to determine for yourselves what the facts are in this case. And the other thing I want to remind the jury of is that an accused has the right to remain silent, and when that silence cannot be used against him, since there was a comment earlier. To the extent that it was commented on, I'm going to instruct the jury to disregard that as well. Go ahead.
I'm sorry, continuing. So it just was that.
It's narrative at this point. He's going to ask his next question.
Okay.
If the state needs to redirect, they will.
You made reference to, well, let me back up from that. Is it standard practice in your agency to withhold information
Yes.
in an interrogation?
Yes, it can be to gauge truthfulness.
And what do you mean by it can be?
So obviously, so a person understands what's going on, you'll give them the basics of why you want to question them. But you're never going to tell them every detail because you want to see if they're being truthful. You want to see what details come out.
So would it be fair to say by saying that it can be means that it's not all the time used in that fashion?
Oftentimes it is. Oftentimes there's information that I won't tell a suspect unless, it's something where I've actually caught the suspect in the act and we both saw the same things. But yes, typically if I want to make sure they're telling truth, if there's certain information I have, I will withhold that. I'll see if they're willing to provide that, and if not, at some point confront them with that information.
You had a partner with you during both investigations, but I'm referring to the second one primarily. With that officer had used the same method if they were taking the lead in the investigation at that point?
Objections, cause for speculation.
Sustained is the form of the question.
Would it be fair to say that the way you interrogate is your method specifically?
Yes.
So it'd be fair to say that that is not standard policy of your agency.
Correct.
You made reference to the suspect's family. Specifically, I'm referring to the children. How were you able to come into the knowledge of the suspect's children?
I believe I asked you about them.
I'm referring specifically to where they lived at the time of the incident.
That was information that came afterwards. Well, actually, I don't recall. I don't remember if you told me specifically where your older daughter lived that day or not.
Well, we be fair to say we saw a lot of the second interrogation. Would that be fair to say?
portions of it.
Well, yeah, portions of it, but a lot of it.
I don't know
Use
exactly how
wise
much
semantics.
we watch. That's really, I guess it depends on your definition of a lot.
At any time, do you recall it being stated where the defendant's children lived?
Not that I can recollect watching today.
Had you seen that video before today? The
Yes.
second interrogation?
Yes.
Have you seen it in its entirety?
Yes.
Do you recall? Well, scratch that. In reference to the second interrogation, in reference to finding the phone, did you ever find the phone of the detainee?
You're asking if I personally did?
Yes.
I didn't, no.
Do you recall where the phone was recovered?
Someone is at front door.
In your vehicle.
Okay, hold on 1 second. Okay, let's keep going.
When you say your vehicle, who are you referring to?
Your mother's red Ford Escape that you were driving that day.
So it'd be fair to say it wasn't my vehicle, as you stated. Grounds.
Sustained as to the form of the question.
And what was obtained from that phone, if you recall?
I don't recall.
Do you recall asking for the code to get into the phone?
Yes, sir, I do.
At any time, did you learn at any time if the phone was able to be opened up?
I don't know if it was or not.
So what would be your reason to ask about the phone code if you didn't intend to open it up?
Objection mischaracterizes the testimony.
Grounds.
Sustained as to the form of the question.
Did you yourself intend to inspect the phone?
No.
So why would you ask for the code?
Well, because for the purpose of the investigation, we have people that are trained in doing that types of thing, getting into the phone, downloading the digital evidence, if they're able. So having the code would assist them in being able to do that when that time came.
And do you recall if it was more than one phone that you were attempting to access?
Yes.
Did you ask for the code for, well, back up. How many phones were you seeking to gain access to?
I believe it was 2.
And do you recall asking for the code for the second phone?
Yes.
Did you inspect the second phone?
Me personally?
Yes.
No.
And from your recollection, what would be the significance of the phones at that point in the investigation?
Well, it's really this digital evidence that could be inside. So as it pertains to domestic abuse, it's not known if there's going to be any phone calls between yourself and Ms. Patterson. Some of the data, location data, can be relevant, although you were arrested in WAUKESHA. It still helps to show that data as well. So things of that nature. We really don't know what could or could not help us until we try to see what's in there.
He's got nothing. Come on, Daryl.
At any time during the first night that you were with the detainee and during the second day, which would primarily be the second interrogation, do you recall there being any drugs and alcohol in related to the detainee?
As in whether you were under the influence?
Yes.
No, you were not.
And do you know that to be fact?
There were no signs of impairment that I observed.
Did you smell any alcohol?
Smell it?
No, sir.
Did you smell any drugs?
You smell it?
No, sir.
And you don't smell drugs. Well, you do. I guess you do.
Did you find any alcohol or drugs?
No, sir.
And during both those days, that the night of the first interrogation and the time spent during the second interrogation, someone was always with you when you had contact with the detainee. Would that be fair to say? Meaning you never had interactions with the detainee just strictly by yourself.
Not that I recall.
So it was always you and someone else.
I believe so.
But you were always with your partner, though, correct?
Well, I mean, he may have used the bathroom at a point. I don't remember. If I was ever alone, it was very short.
But from the best of your recollection, you were just never, for a period of time, just by yourself with the detainee.
The second day before transport, there was a period of time when Detective Stern stepped out of that interview room at Muskego. And I don't know how long it was just you and I in the room, but that's all I recall.
But nothing extended from your recollection.
No.
And was it your belief at the time that you were set to conduct the second interrogation that you believe that without the FBI present, the detainee would likely be more willing to speak with you?
Objection. Speculation.
Grounds.
I'm sorry, can you repeat that again?
Was it your belief that the second interrogation without the FBI's presence, was it your belief that the detainee would be more likely to speak with you at that time?
He may answer. Go ahead.
Yes.
And do you recall how you came to that determination?
Yes, it was a sense of how I felt you interacted with me, the night before. As I stated with you, or stated in testimony, we had casual conversations. Part of those casual conversations were talking about sports you played, sports you enjoyed, the Packer game that day. You seemed very calm, very relaxed. You are, and you know what you're doing right now.
Would it be fair to say that you can't say for sure how I'm feeling at this moment?
Objection. Not the question that was asked, and argumentative.
Sustained as to the form of the question.
Would it be fair to say that at the time of that first interrogation, you weren't sure how I was feeling?
I guess I can't get in your head, but you presented yourself as being very calm and very comfortable.
Based on your observation?
Correct.
Do you yourself have any training in psychology?
No, sir.
And there was a point in the second interrogation when you were attempting to show the detainee a video. Almost as if you was forcing it in his face.
Oh. Awesome.
What were you attempting to show the detainee?
I was attempting to show you a video of when you drove your vehicle through the parade route.
Any reason why you were being so forceful in trying to do that?
Do that?
Well, I felt it was very important for you to see the damage that was caused from the incident. And Detective Stern made the statement as well. You were asking for more information, so we attempted to show you more information.
Would it be fair to say that the question of asking for more information was asked even on the first night during the first interrogation?
Yes. Yes.
Chili.
Do you recall making a report of the night that, let me back up. Do you recall writing a report of your interactions with the detainee on the first night and the second morning?
Yes.
And did you write the report yourself?
So how it's done is I dictate it and then it is typed by someone else.
What do you mean by dictated?
So there's a phone system that I talk into and it's recorded and then it's later typed.
Do you recall who types it?
One of our clerical staff, I don't know specifically who it was.
So you made reference to a phone. You gestured with your right hand and made a phone, I guess, symbol. So I'm assuming that that records what's being said. That'd be fair to say?
Yes, when I'm speaking into the phone.
And at that time, speaking into the phone, were you stating verbatim? Was it off the top of your head what you remember, or did you, I guess what I'm saying is, did you speak into that phone based on a report that you had already previously written or had obtained?
Well, I guess I want to make sure I understand the question. Could you ask it again so I understand?
I guess I can be more clear.
Oh no, you can.
I guess what I'm trying to say is, like, by speaking into this phone, would that have been what you recalled at the time, or would it been based on a report that was already written by you or someone else?
Okay. There was no prior report, so that what I speak into that phone and what is typed is my best recollection of the events at that time.
I just gave you a little clarity. I knew what I was trying to say, I just couldn't.
You're not any of these people's friends.
So at that time, when you spoke into the phone, you hadn't yet filed your report at that time.
Correct. As I'm talking, I'm completing it. So it goes into a recording and then it's later typed.
And then is it filed after being typed?
Yeah, eventually it's sent to court.
Do you recall if that was, I'm guessing that would be the night of the second interview or sometime after that?
Yes, it was the night of the second, after that interview had been completed.
After that second interrogation, had you learned any more information additionally that you didn't have during the first and second interrogations?
Yes.
And did you put that into your report?
I believe I did, if it's the one thing I'm thinking of, yes.
Do you recall how many reports you filed in relation to this incident?
I think 4, maybe 5.
Why so many?
Well, you have to understand that after the second interrogation, the investigation wasn't simply complete. There were additional things that need to be done, and additional things I assisted with that led to other supplements being done.
And do you recall, well, let me back up a minute. You said 4 or 5 reports?
I believe so. I don't know the exact number.
Do you recall when the last one was completed?
I believe in June.
And would the June report contain additional information that you didn't have in November of 2021?
I don't recall either that or clarification. I'd have to see the report, I guess, to know exactly what you were driving at.
You don't recall what you reported?
Not exactly.
Do you recall what you reported in the second report?
Not exactly, no. I believe, I don't want to speculate.
So it'd be fair to say you don't recall what you reported in any report except for the first.
That is the one that is most clear because it was such a substantial piece of what I did in this investigation.
And that was the one when you spoke into the phone and it was recorded and then typed?
Well, they were all done the same way.
All reports are done the same way.
What is he getting at? Oh my God. Does anybody know what he's getting at? Does anybody understand if he's got a point that he's getting to? Because he's losing me here. I'm completely lost. Are you getting at that he didn't follow some kind of procedure? Are you getting that every police interrogation procedure has to be the same? Or it's unfair? It's unfair. It's unfair. It was unfair. The goblin, cry of all goblins that it's not fair. Do I think it's necessarily a fair fight that the police are legally allowed to lie to you during these questionings? Maybe not, but can we see why it has to be done? Look what they're dealing with, the ilk that they're dealing with. Oh my gosh. Ugh.
And do you recall coming to the Waukesha County Jail to serve any warrants in relation to this incident?
Yes, I do.
Do you remember what they were for?
Yes, it was a search warrant for your jail property.
And do you recall what that jail property was?
Property that would have been turned over to the custody of jail at the time that you were, so personal belongings.
And what would personal belongings refer to exactly?
Are you asking, it could be anything you had with you. Are you specifically wanting to know what I seized?
Yes.
Your red t-shirt that you were wearing on the 21st and 22nd of November, the blue jeans, as well as socks.
And do you recall why you needed to seize the clothing?
Yes, the determination was made to go back and seize the clothes as it's the items you were wearing during the event. The parade event is what I mean by event.
Would that be the only reason why you needed to seize the clothing?
There was also possible DNA evidence, but I do not know how that came back.
Did you yourself inspect the clothing?
I just retrieved it from the property, put it in a bag, and brought it back to the police department.
Do you recall if you seized anything else besides the clothing?
Not from your property at the jail, I didn't.
And do you recall if that was the only time you came to the Waukesha County Jail to serve a warrant?
Correct. That's the only time I recall.
Do you recall when that was?
November 30th, 2021.
So roughly about a week after the incident?
9 days.
And you made reference to bringing it back to the department. Did you learn who would be expecting the clothing?
No, I believe it would have gone out to the state crime lab.
Did you obtain any additional information from the state crime lab?
I don't believe I received any information from the state crime lab personally.
I want to go back a little bit, specifically to the night of the arrest. When did you arrive on scene to Elizabeth Street?
Shortly after you had been taken into custody.
When you arrived, what did you see?
Can't recall exactly. I believe you were already in the back seat of a squad car.
So at that time, suspect was already detained.
You were detained.
Suspect already.
Suspect
detained.
is you, Daryl Brooks.
Can you strike that last comment?
That was his response.
No.
He will stand.
And did you do any search of the area at that time?
I did not know.
And what did you do from that point?
At that point, myself and Detective Stern were assigned to follow Specialist Mark Howard, whose vehicle you were ultimately placed in, and follow him to our substation, where you were taken.
Do you recall well, let me back up. Do you recall seeing a lot of different law enforcement there from different jurisdictions?
Yes, I do.
What else do you recall about the scene as far as law enforcement personnel?
Basically just that they were there.
Do you recall any weapons being drawn at that point, or?
I did not see any officers with weapons drawn when I arrived. There were officers with rifles across their chest, but they were not pointing them at anyone.
Any distinct vehicles, to your recollection, utilized by law enforcement?
Just squad cars, marked squad cars that I recall.
Do you recall seeing a vehicle that was more like a ground rover type vehicle?
No, sir, I don't.
And so once you came to the scene, learned that the suspect was in custody, you followed the other officer to I'm guessing the police station or whatever it was?
The substation.
Substation. I'm sorry. Substation.
Yes.
Why are we going back to this? How did these people stay awake for this? Ugh.
And what information did you have at that time in regards to the investigation?
The information, again, was still very limited. That you'd been loitering in the area, would receive calls, and that you were identified as a possible suspect that was in the vehicle.
Did you yourself receive those calls or any of those calls?
You mean as in like the phone calls?
Yeah, in reference to the loitering.
No, those went into dispatch, and then they were broadcast over the police radio, which I heard.
And did you immediately respond to that radio call?
Respond to it?
Yes, I made my way to that area.
The area of Elizabeth Street.
Yes, sir.
Do you recall what time that was?
It was right around, took place over a few minutes, 5:30, 5:35, getting a little after 5:30.
And what time did you arrive to the scene?
I don't know the exact time.
I want to go back to the phone really quick in reference to the phone. In the exhibit that we were shown, you made reference to not wanting someone else to claim the phone. Do you recall saying that?
Yeah.
Yes.
What reason would someone else claim a phone that isn't theirs?
Could be their own reasons. One thing we have to do once we have possession of property, we have to make sure that we release it to the appropriate person. So that would be important.
Is it fair to say that all property obtained from a detainee is sealed?
I guess, what do you mean by sealed?
Like placed in a sealed bag, pursuant to whoever's the property belongs to, it's sealed.
Typically, we would take property and probably put it in a paper or plastic bag. We don't necessarily seal it and then place it in a locker.
Would you write on the bag who the property belongs to?
Well, if it's personal property and it's going to be returned, it would go in a locker, typically that's associated with their cell. But if it's evidence, it would go, to a different place. It depends on the type of property you're talking about.
Would it be some type of identifying something to identify the property to the owner of the property?
Yes.
When you came to the Waukesha County Jail to serve the warrant for the clothing or personal property, as you stated it, was that property sealed?
It was in a secure room.
Was it sealed?
Like the bag it was in? No.
The bag was just wide open?
I don't recall if it was wide open. They have it in a property bag that I don't remember the exact conditions of it.
Did it have any identifying name on it, or a birth date, or?
They utilized a system in which they looked up your name and the bag had a number. The number was associated to your name. So they were able to find it that way. And then, I mean, once I got in the bag, I recognized the clothing as your clothing.
So it'd be pretty fair to say that the system that they use is pretty easy to identify what property belongs to whom.
It seemed to be. To get the specifics on it, you'd have to ask them, but I mean, they looked up your name, hit a number, and your bag came right across.
Does your agency use a similar method?
No.
And what method does your agency use to identify a property?
My agency would simply, well, we're not a large county jail, so we only hold about 5-6 people at a time. We would take personal property, put it in a paper bag, put that paper bag in a locker that typically would correspond with the cell number that you were placed in. And then your property would also be documented on an electronic form, so we knew it belonged to you.
You made reference to not being a large county jail. Are you referring to the holding station?
Our standard department that we're back in now has a municipal lockup. Correct. It's very small.
So it'd be the holding station.
They call it the police station, the booking room.
Police station, substation, holding station.
Yeah, correct.
Now he doesn't care what it's called.
At any time during the second interrogation, were there any other law enforcement watching the interrogation from another location?
Yes, there were.
Can you explain why?
Well, again, the FBI was present in a different room because we still did not know whether there was a terrorist nexus to this incident at that point.
Is that the only other law enforcement that was watching the interrogation?
There may have been some of our own officers. I don't know if they were moving around the building, or I don't know what they were doing.
So it'd be fair to say you can't recall if
Correct.
If at that time there was still uncertainty about the nature of the incident, to the point that the FBI still were kind of involved at that point, any reason why they wouldn't accompany you and your partner for the second interrogation as they did with the first?
Objection, relevance.
Grounds.
Sustained. Relevance, 90611.
Is there any reason why the FBI couldn't induct their own interrogation?
Induct.
Objection. Cause for
Grounds.
speculation.
Sustained.
Thank you. It's true. Just call for speculation.
If you knew at that time that you and your partner would be conducting the second interrogation, why did the FBI need to be present?
Objection, relevance.
Grounds.
Asked and answered. Next question.
Answer?
It's sustained.
You said asked and answered?
You've asked why the FBI was there multiple times.
Yeah.
90611.
You did.
Please move on.
Is it standard procedure for other law enforcement to watch interrogations from another location?
Objection to relevance.
Grounds.
Overruled. You may answer.
I wouldn't say it's standard, but this wasn't also a standard incident.
So the magnitude of the incident is what prompted the change?
That's right.
I can't tell if Daryl is proud of the level of carnage he created with his goblin stomp, or if he's trying to say it was totally unfair the way they questioned him about his goblin stomp. Ugh. The magnitude. Ugh.
Do you recall who made that determination?
Objection calls for speculation of relevance.
Yes, do you know? So overruled. The witness may answer.
So I'm sorry, just so I understand the question correctly. Why the FBI is the question why they'd be there at all?
No, that wasn't the question.
What is it again?
The question was pertaining to standard procedures.
Okay.
And I believe the question was,
You asked who made the determination to allow for other agencies to observe the
Right.
interview or interrogation.
thank you, Your Honor.
You're welcome.
I don't know exactly. I only know that the FBI became involved due to the terrorist concern, so that's why they were there.
My question wasn't towards the FBI. It was
Yeah,
law
yes, it was.
enforcement in general.
He doesn't know what his question is.
Just to give more clarity, the question was,
Cut your fingernails.
did you know who made the determination for other law enforcement to watch from another location?
No.
Were you at any time aware that there would be other law enforcement watching the second interrogation?
I knew the FBI was coming back, yes.
Did you know if there would be any other law enforcement outside of the FBI, like from your agency or anything like that? Were you aware that they would be watching as well?
Objection to relevance.
Grounds.
Overruled. The witness may answer.
Not that I knew of.
One time, I was on, I'll never forget this, Medic One. It's important to know it's Medic One because Medic One was like the pinnacle of busyness, and we were the central medic, and we got called on everything. And so, we're driving out to this call, and behind us is the battalion chief. You don't want the battalion chief following you. It's almost as bad as having like their chief following you. You don't want their chief coming out or calling you in or anything else. And what we discovered, it was the battalion chief and the medical director. And they followed us all the way to the location, which was a completely different district. It wasn't even our first area. So we get out, I do a quick assessment on the patient. It is basically a typical homeless person, probably cold, most likely intoxicated, most likely some kind of comorbidities. Did he have to be rushed to the hospital? Probably not. It was probably a combination of, Starbucks didn't want him on the doorstep and he didn't really have any place to go, and he may have been sick on top of it. And the medical director came over and asked about the background of the illness. And I'm like, well, he's got an emergency testicular cancer concern. Like, I don't know what his concern is. It doesn't appear to be anything acutely wrong with him right now, but we're going to take him to the hospital. Did you want us to go talk to him? He didn't want to. Point of the story is, we don't know why our supervisors come and do things or add people in. They just do, and you continue on with your day. So
But you
gross,
do
dude.
recall other law enforcement outside of the FBI being present.
Yeah, so we had an officer, based on you being in our custody, that had to stay in the room with you, their jail area for the night. I don't know how much of the interview that officer was or was not present for from another location.
Do you recall leaving out of the interrogation room during the second interrogation?
Leaving out.
Yes.
And at that time, did you speak with any other law enforcement?
FBI.
And do you recall what those conversations were about?
Not specifically, no.
Do you recall if there was directives given by the FBI?
Objection, hearsay.
Grounds.
Yes, do you know? Not what they were. You may answer.
I don't recall if they gave directives.
Do you recall your partner stepping out of the interrogation room at any time?
Yes.
Do you know if they spoke with FBI at that time?
If my partner did?
Yes.
I don't know.
At any time during the second interrogation, did the FBI leave?
Not that I know of.
So to your recollection, they were there the whole time.
I believe so, yes.
And I want to go back to the phone for one quick second. You made a reference to the kind of code on the phone. Do you recall what that was? In reference to the phones that you were intending to access.
You talking about, there were two, one of any one phone specific? You talking about the iPhone?
Yeah, the iPhone. I'm sorry.
Yes, you gave a pattern code.
And what about the other phone?
No code was ever provided that I recall.
And do you recall if those two phones were placed in the evidence?
Yes, they would have been.
And did you place them in evidence?
I did not.
Do you recall whom?
I do not.
During your investigation, what? Let me back up. I don't want to say what. You made reference to the suspect being involved. During that initial information that you received, did you receive information that there were multiple suspects at any time?
We're talking about the parade incident at this point, yes, no?
The parade incident, yes.
Initially, yes. So, and I've covered this in prior testimony as well. It was very chaotic early on, and there were reports of possible multiple suspects, yes.
Just about does it. No further questions.
Oh, thank
Sure.
goodness.
I have some. I would think I could get done in 10 minutes.
All right, I'm just going to have my jury stand for a minute. I need one too. And anyone else in the courtroom may do that.
Oh my gosh. Yeah, everybody stood up, Daryl.
All right, thank you. Please have a seat.
Exhibit 174, which has previously been admitted into evidence. Do you recognize this form?
Objection, lead.
Overruled, the witness may answer. It's been testified to previously.
Yes, I do.
Sir, if you talk to the same person 3 different times while they're in custody, do you have to fill out a separate form each time you talk to them?
Objection.
Overruled, the witness may answer.
3 times.
Yes.
Would you have to fill out that top portion of the form each time?
Yes.
That's all I need for that exhibit. When we talk about, do you recall Mr. Brooks' questioning of you with regard to the recording
Objection.
made by your cell phone at Waukesha
finish
Memorial
the
Hospital
question?
during the first meeting with the defendant?
Objection. I don't consent to being called that name.
But he's gotten it.
Voted overruled, the witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I
Objection,
am.
leading.
Oh, overruled, the witness may answer.
Sorry.
What is that?
It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord and not response to a question. Typically, an utterance may reference why they're in custody in the situation that you were either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape or recording?
Objection, speculative.
Overruled, the witness may answer.
Yes, it is.
Would that be a reason to continue recording after an interview's been ended?
Objection, answered that already.
Overruled, the witness may answer. It's redirect.
Yes, it would.
With regard to the 2 phones, you indicated that someone else located the phones in the defendant's car. Is that correct?
Yes.
And in order to access the contents of a phone, if it's passcode protected, do you need the passcode to enter it?
Objection, leading.
Overruled, the witness may answer.
It makes it easiest. The men that do that, the men and women that do that, do have ways around it, but it makes it much more difficult without it.
And would it be fair to say that there's not all software can entered to all phones without the passcode.
Objection, speculative.
Sustained as to foundation.
Have you had experience in your position as a detective seizing phones off of defendants?
Yes.
And have you had opportunities to turn those phones over to your forensic unit to have them analyzed?
Yes.
When you don't have a passcode or a swipe pattern, have you received those phones back with information that they were unable to be accessed?
Objection. Asked the form of that already and answered.
Overruled. The witness may answer.
Yes, I have.
So if you're not provided a code or you're provided an incorrect code, there's a possibility, or are you definitely getting into that phone?
Objection, speculative.
Overruled.
No, there is certainly a possibility that we would not be able to access the content.
You had talked about on cross-examination your reports that you dictate over a phone line. Do you recall that?
Yes.
Those you testified were based upon your recollection?
Correct.
Do you take notes during interviews?
Objection, speculative.
Overruled.
Speculative.
You may answer.
Yes, I do.
Do you use those notes at all when dictating your report?
Yes, I do.
The defendant asked you about multiple suspects, you having information about multiple suspects. Do you recall that line of questioning?
Yes, I do.
Did the defendant ever tell you that there was anyone in that car other than him driving it and possibly Erica Patterson?
Objection, leading the witness.
Overruled. The witness may answer.
No, he did not.
And finally, you've been a law enforcement officer in Waukesha County for approximately 18 years, is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
Objection, leading.
Overruled. The witness may answer.
The prosecuting attorney at the Waukesha County District Attorney's Office.
You don't decide on the charges?
No.
Objection, relevancy.
It's overruled.
We
You may answer.
we can forward what we believe is appropriate, but we don't ultimately make the decision to charge.
So when Mr. Brooks asked you, what am I being charged with? Did you have any ability to tell him that?
Objection, I don't consent to being called that name.
Noted. Overruled. You may answer the question.
No, ma'am. Not with 100% certainty, no.
Thank you. Oh my gosh.
Nothing further, thank you.
All right. Thank you. Detective, you may step down.
Hallelujah. Oh my gosh.
Ladies and gentlemen of the jury, as Detective Carpenter is stepping off, I will read the instruction that I've read to you every day, but it's important that you hear it again. Do not begin your deliberations and discussion of the case.
Thank heavens. I'm sorry I kept that small instead of expanding it. We will be starting day 10. Let me write that down. Day 10, day 10. Oh my gosh. Down to the last third of this nightmare. That was painful. That was actually pain. I'm actually in pain. Woo. Okay, thank you for sticking it out with me. Oh my goodness. I will see you later. Bye, friends. Like, subscribe, and comment.